We're going to get started this morning. Welcome. Today we're talking about title and survey objections and how they're treated under the Naples Area Board of Realtors contract. My name is Sam Saad. I am an attorney in Southwest Florida, and because I'm an attorney, today we're going to start our presentation with a disclaimer that I'm providing advice that's not legal advice, and if you have any questions or need an attorney-client relationship, we have to set them up separately. A little bit about me, your speaker today. I specialize in real estate law.
When
I
you
have
get a
served
chance,
on
I
the Naples Area Board of Realtors and the Florida Bar, Florida Realtor Joint Drafting Committee. Um, these are the committees that draft your contracts. I very much enjoy that work. My office is in Naples, and we have a full service firm for real estate, business transactions, litigation, probate, estate planning. And we're happy to help you throughout Southwest Florida, whatever we can do. We have a title company as well, Paradise Coast Title and Escrow, for all of your closing needs. We guarantee will be the lowest closing fee. We are always up to date on the latest and crazy changes in our industry, and we have been implementing and adding security measures to combat so much of the fraud. If I can help you with your closing transactions, please feel free to give me a call. My cell phone number is on the screen. And I'm excited to be talking about title and survey objections today because it's so much of my job and what I do to make sure that you get to closing. So just a few thoughts as we get into it. One, you are selling marketable title. So it's not fee simple or clear title, it's marketable title, which is a title that you can resell. And the funny thing about marketable title is it's really what two lawyers agree it is. There are title standards. Um, there are there's a 1,000-page book that I have that was written 50 years ago called Marketable Title by a bunch of lawyers, and they can't agree on what marketable title is. So it's really a title that you can resell or that we can get a title insurance policy for. There will be exceptions on the title, so it's not like absolute fee simple title when you close a transaction. Things like the neighborhood covenants, these whatever else might be on there for easements. And then don't forget about the survey. It's the second most important document in the transaction after the deed. It is the only document that tells you where your property is on the earth because your deed does not contain an address. It contains a legal description. So if you know where block 13, block F, lot 13 is in Naples Park, then you know where I live. Or if you can go look up my address, then you'll be able to find it on the map. Well, the map comes from the survey. So don't skip the survey. Let's talk about title to the property under NABOR. So marketable title is defined by the Uniform Title Standards. This is a 300 plus page manual put out by the Florida Bar that talks about the title standards and what happens in a variety of different scenarios as to whether you can issue a title insurance policy over a particular issue, such as when a husband and wife convey, but she doesn't sign, or she signs later, or she's considered incompetent. Those are the title standard issues that are all dealt with in this manual. And that's what governs your contract, NABOR and FARBAR. And you can see here in the language in the contract, title to the property shall be good and marketable according to the uniform title standards promulgated by the Florida Bar and have legal access subject only to the following exceptions. So there are exceptions, four types of exceptions that you can take title to in a NABOR contract. Obviously, you have to pay your property taxes. So you take subject to the duty to pay taxes. Zoning and government restrictions, you take you take your title subject to the whatever the city or the county says you can build on the property. Any recorded mineral and gas rights in the property are also going to be an exception on the title. And those are things like if you're in Collier County and the Collier family owns the oil rights under your property, You can't drill for oil on your land. Now, they probably cannot either because of other restrictions, but they ultimately have the right to, and that you take subject to that right. And then, of course, you take subject to your association, your homeowner, your condominium association restrictions. Those are all in your CCRs and your declarations. So what we do is we examine the title. We look at everything on the title in the examination period. And the way that works is the seller has 10 days to give the title insurance policy from when they bought the property. It's 10 days after the effective date to get that policy to the buyer if they have it. If they don't have it, just say, I don't have it. And then we conduct our own search, go back 30 years and do a search without the prior policy. And then the examination period is defined by the contract where the buyer has 30 days to examine the title. That's a little bit long, but that's what the contract says. And again, what you're looking for are the defects. Is there access? What other documents are on the property? Has the seller recently passed away, and do we need a probate? These are title issues that we're looking at, and you have 30 days to do it. And of course, I said the property must have legal access from a public road. So if there's a private road giving access to your property, one of the title issues that we're going to be looking at is how does that private road operate? Is there a written road agreement? Who provides the maintenance for that road? And things like that. We have to get all the way back to a public road. If there are title issues, and there are always title issues, the buyer has to notify the seller of the title defects during the 30-day examination period. I will tell you in my office, title examination takes a couple, 3, 4 days. We get the policy, I'm sorry, the commitment, the title commitment over to the seller. The seller clears the title, and as long as it's not too bad, we go to closing on time. One thing that the buyer has to do when they get that title commitment in, that title commitment's going to have a bunch of attachments to it. One could be one for each title requirement and exception on the policy or on the commitment. And all those documents have to go to the buyer as well. So typically there'll be a Dropbox or email full of links to all the documents from the underwriter that gets transferred over to the seller so they could review the title. So then the seller then has 30 days from receipt of the objection to clear the title. That's 60 days now to clear title if you needed it. Now, do we ever use that much? I would say almost never, but it is in the contract. And the seller may be forced to sue somebody in the clearance period. Now, can you bring a lawsuit in 30 days? You can certainly file one. Can you get it resolved with the court? Absolutely not. So that's an interesting point in the NABOR contract where you have 30 days to clear title. But if the seller did have to quiet title, for example, against an heir or some other encroachment, then the seller would probably need an extension of the clearance period to get that resolved. And the seller is not liable to the buyer if the seller cannot clear the title in the clearance period. So the buyer does not get damages if they've done inspections, they've paid for the lender, and then all of a sudden the seller can't provide marketable title. If the seller fails to clear title in the clearance period, the buyer has 5 days to make a decision. So you got to be paying attention to your deadlines here. When was the title commitment delivered to the seller? And 30 days later, did the seller clear title? If not, the buyer has 5 days to terminate, or the buyer takes title as it then is. And that gets crazy because the buyer could be forced to take title subject to, say, the seller's mortgage. And could you imagine if you're a buyer trying to get a mortgage, then you got to have another mortgage that you have to deal with, or you lose your deposit? So paying attention to that clearance period deadline is very important when there's a lot of stuff on the title for the buyer. If we do have an extension of closing, we either go to the closing date or 10 days after expiration of the clearance period. That's our new closing date. So the interesting thing though, monetary liens under the contract are not title defects. So if, for example, the seller did have a mortgage to pay off, they couldn't go and say, well, I can't get this taken care of by the closing date, so I don't have to close, because it's a monetary lien. HOA liens, code violations, things that can be paid with money, the seller has no choice but to pay them off at closing. So you'd be very cautious there about making sure that you are not going to be in what we used to call a short sale situation, where the seller may have to come to closing with money because there's so much stuff on the title that they have to clear off. So before I switch over to survey objections, are there any questions? And you can unmute yourself. Any questions about the title examination process?
Sam, I have a question about.
Yes, Ksenia, turn your volume up. I can barely hear you.
Oh, can I get these slides to the show sometime later when you're done?
Oh yeah, I'll email you the slides. Absolutely. We send out the slides and we post the videos to YouTube.
Okay, thank you.
Sherry, do you have a question?
Yeah, I am used to Wisconsin where we can't have any liens on the title, right? How do we be careful to protect our buyers in this situation?
So if you know what a title commitment is, of course, right? That's the
Yeah.
document that shows the buyer what all the issues on the title are.
Right.
So we clear all of the liens off the property unless
Right.
there's some reason that they would stay on the property, like if the buyer was going to take subject to a construction lien for, because they're buying a house in the middle of being built, for example. But there won't be any liens on the property at closing. There are exceptions on the title for things like the taxes and the HOA dues and things like that. But I got to imagine even in Wisconsin, you would take subject to your property taxes.
Yes, maybe I'm misunderstanding what you're saying. And in terms of when you're saying, I'm asking a bad question, so you can move on.
All right. Well, if you think of a different one, please shout it out. I mean, everyone probably has the same. A lot of people have the same understanding of these things, and I want to make sure everyone
Yeah,
understands.
I mean, I've been down here for almost 5 years, so it's not like I'm actively practicing in things. What throws me every time is the title company saying to us, and so you're a different title company, maybe correct us, where they'll say, yeah, we don't, lien defects and things are not we can still close with those. And I'm like, and then what are we?
I've never heard of a lien being able to be closed over without a specific exception on the title policy, and you typically don't want that if you're a buyer.
Of
So
course.
someone is giving you bad information, and if you want to show me the deal afterwards, I'll happily go over it with you and make sure that you got it correctly done.
Yep. Okay.
But
Thank you.
that's not correct. You would
Okay.
never close. I'm not saying never, but rarely ever would you close where there was a continuing lien on the property that was not one of the permitted exceptions that I mentioned, those four earlier.
Yep. I guess in the one most recently had to do with not necessarily a lien on the property, but it was outstanding bills that were not disclosed that got tied to the property with the new buyer. And then
Well,
the
that's
buyer's having
interesting
to deal
because
with it
you
after.
are required to pay off everything that's on the property, like HOA liens and back taxes and contractor liens and anything else at closing. So yeah, do me a favor. If you want, shoot me an email afterwards and I'll call you and we'll talk about it. Because that's an interesting, you may have somebody may have made a mistake there that we have to correct.
Yep. And the other one, just one more second, was also the open work permits.
Yeah, if you have open permits on the property, those are not liens. Those are not, they do not affect the title to the property, and the buyer would take subject to an open permit unless they properly did their inspection election and got it closed. So that's the open, I should say this, open permits and code violations, unless the code violation has been reduced to a lien through the proper county process, Code violations and open permits are not title objections that are subject. They don't show up on your title, so they're not part of the title clearing process. They're part of the defective items process. So when you're clearing like your inspection items, that's what I'm trying to think of. All right, let's talk about survey objections. Unless the property is a condominium or a co-op, the seller has 10 days also to give their survey to the buyer. Now, the survey that the seller has to provide, they have to have it in their possession and it has to be certified to the seller. So if the seller has the survey from when they bought the property from their seller, that survey doesn't help anybody. We don't use it. The buyer has to get their own survey. So also you turn over the flood elevation certificate if you've got it. And if there are no changes on the survey that the seller turns over, then the contract says the seller shall sign an affidavit of no change. So these sellers, they push back and they say, I don't want to sign this affidavit. I'm saying, well, you told me you didn't have any changes on your survey. The contract says you agree to sign this affidavit. So if the buyer can survey the property, if they want to, and I strongly, strongly recommend that you do a survey up until 5 days before closing. NABOR gives you a lot of time to get your survey done because they know people don't want to incur the expense of a survey if they're not going to buy the property, like in an as-is situation. So they give you until 5 days before closing to get the survey. And you must use a licensed surveyor. Now, when you get the survey, if it shows objectionable items, there are actually 7 items that a buyer can make objections for on the survey. They can object to encroachments on the property. That means that somebody else's fence is on my property. They can object to improvements located on the property that project onto the lands of others. That means my fence goes onto somebody else's property, the neighbor's property. That's always the big one. You know, the air conditioning pad is in the setback. The neighbor's fence is on my property, things like that. An improvement of the property violates a zoning, building, or other governmental use restriction. And that would be, again, that's like the air conditioning pad in the setback or something like that. Improvements violate the covenants. That could also be if the HOA documents provide like a drainage easement or utility easement, and your pool cage is the corner of your pool cage goes into the easement, for example, or your air conditioning pad is in the easement. Things like that would be an improvement that violates a covenant or restriction. If the property does not meet the applicable development standards for the local government, things like a non-conforming illegal structure, like somebody put a shed on their house in the estates and it's too close, it's not permitted, or it's too close to the neighbor's property. Those are applicable government standards that that could be a violation. And then the last one is the lack of legal access. Again, you're not on a public road and you don't have a private road that's clearly delineated or a right of use, or you're buying a flag lot, for example, and you've got to get back off of the main road to get to the property, things like that. So survey objections, you make your objections, they're treated as title defects within the clearance period. But remember, your clearance period starts when the survey is delivered, with the objection letter is delivered to the seller. So you really could have 2 clearance periods going, one for your other stuff and one for your survey objections. And closing could be extended up to 30 days if you had survey objections that needed to be dealt with and someone didn't get their survey until 5 days prior to closing. So be careful about getting the survey. And when we order in our office, we'll order the survey right away because we don't want there to be a big delay in closing if there is an encroachment. Now, if the buyer does not get a survey, was there a question?
Just
Katya?
2 questions. Yeah. If the seller provides the survey to the buyer and there hadn't been no changes, does it get recertified to the new buyer? Who does
It
that?
can be, we can contact the survey company. They have some paperwork to do to recertify. They may need to go back out to the property, but they could recertify to the buyer. Yes, they can.
Okay, and do you or your title company, do you, because I've gotten title commitments with exceptions and all that, it's difficult to really understand what might be a problem. Do you specifically point out to the agent things that should be addressed?
Well, in my office, we will send the buyer and the seller and both agents the survey objections, the title and the title objections. They'll get all that as it comes through our office. What I typically ask the realtor to do is review and call me with questions, because I deal with it. I don't ask very often. I mean, if there's a lien, like a construction, a contractor's lien on the property, I will talk to the realtor about that and say, hey, listen, can you go to the county and get some paperwork for me? Or can you call this contractor and get the payoff and help me with that? But 99.9% of the time, we just handle it. We'll call the contractor, we'll call the county. So I don't really call the realtor and explain the problem. I just solve the problem. Let's see here. You're asking, Michael, because it's come up a couple of times, can the notice be delivered to the seller's agent? Yes. Yes, Michael, we send it out to the seller, the seller's agent, the buyer, the buyer's agent. They will get all the objection, both parties get all the objection stuff, and then we work it out, we talk it out, we have a closing. As I say in my office, if you bring me a contract, I'll bring you a closing, because you don't get paid and I don't get paid unless there's a closing. So we will close. We may just have a lot of work to do, and we just do it. We don't mind it. And then let's see, Jessica, you were saying, does your office send an email to the buyer outlining the importance of having a survey done? We do talk to the buyer about getting a survey. We have an email that suggests that they do that. But we actually rely a lot, and this is why I'm doing this seminar, on you, the realtor, to get the information to the buyer, because they trust you. They worked with you, they know you, and they trust you, whereas they don't know me, they may not trust me. I'm just the closing agent, the title lawyer, and I don't have that deep relationship that you have with them. So just a couple more thoughts on the survey. If the buyer does not get a survey within the survey period, then the buyer waives the right to object to any matters, and there are exceptions on the title policy. So if that air conditioner is in the setback, your buyer takes the property with the air conditioner in the setback because they didn't get their own survey, and then they go to sell in 5 years, they're going to move the air conditioner if their buyer wants to make an objection, and it's going to be all on them, and they can't go back to the seller. If the buyer does not make any survey objections as well, even if they get a survey, they waive their right to make objections. So be very careful there about getting your stuff done and getting it done timely. Okay, one last thought, then we'll just have questions. I see some questions piling up. If any portion of the property lies seaward of the coastal construction control line, then we have to give a disclosure in the contract. And if the property does lie seaward of the coastal construction control line, in the NABOR contract, the buyer waives their right to receive the affidavit and the survey showing the CCCL. So what is the CCCL, you ask? It is a line on the map, and you can see it on your screen, that runs up the coast, and basically everything on the seaward side of that, it's got to be on stilts, it's got to have blowout walls, it's got to be 18 feet in the air, it's got to have all this other stuff that you see. That's why those giant houses on the beach are so high in the air. It's not that they're 3- and 4-story homes, it's that they're built up on stilts so that when this hurricane comes, the water washes under them. And with that, I am really excited to take any questions that you have today. So shout them out or put them in the chat. I know surveys and title objections get a little hinky sometimes, because it's like, what is what? Does anybody have any questions? I can't be that good.
Can you hear me, Sam?
Yes, Marcia. Go ahead, Marcia.
Have it need to provide that.
Marcia, you're breaking up.
Let me
Marcia.
turn off my microphone, see if this is any better. Can you hear me now?
Yep.
Okay, so the survey, if the seller has it, has to be in the seller's name for them to pass it on to the buyer, correct?
That's right.
So obviously, if they got a survey from their, when they purchased, they're just, it's not in, they haven't ordered a new survey. Could they have recertified it then from the previous seller survey? Is it a possibility and get it in their name in that manner? Or do they need to order a whole new entire survey to provide that under under those terms?
Marcia, you're breaking up a little bit. I'm going to answer your question two ways. I'm not sure exactly what you're asking, but basically, if the seller has a survey that is certified to the seller has to give that survey to the buyer. If the seller has a survey that's not certified to the seller, then the buyer needs to get their own survey. And I strongly recommend that the buyer get a survey.
And what do
Even
those
if the
surveys
seller
cost?
has a certified survey, I still recommend the buyer get their own survey, because you never know, and it's just so important that the buyer know what they're buying. This is the only document, the survey is the only document that shows what you're buying. The legal description is great. Like I said, Lot F, Block 13, Lake Park subdivision, Naples, Florida. That's where I live. Where is that? You don't know, and I don't know, only because I've been there. But if it's on the survey, then there's an address, there's a legal description, its related properties around it are on it. It's much more comprehensive and clear. Jessica, you're asking about open permits. Just briefly on open permits. If a permit is open, you have to go to the county, you have to figure out what the resolution is, why it's open, get a resolution report from the county or the city, and then you have to do whatever is required to get it closed. It may pay money, it may mean an inspection. Those are typically the two things that are required. Work may have to be completed and then re-inspected, and that's how you close open permits. Other questions?
Hi,
John?
my name is Alex. I want to ask a question. It's again regarding the open permits. Am I allowed?
Of course.
Okay, so I'm currently I am under the contract, and my buyer is still in the due diligence period. And now we do have an open permit. However, the closing is set for the October 1st, so we do have a little bit over 30 more days. And now my pretty much buyer requested from the legal team for us to close the permit that we have. And my lawyer said pretty much that he's going to start right after the due diligence period. And my seller, on the other half, have a question regarding that, because he doesn't want to close the permit, unless they become a new owners of the property. So my lawyer said that we pretty much have to do it right away because it's going to take some time. Now, my question is that allowed? Like, can we actually wait until the last day, maybe a day before the closing or at the closing, or we have to, just close the
That would
permits?
probably be considered not acting in good faith if you waited till the day of closing to do it.
Mhm.
I would get all the paperwork, I get everything done, and then I would get you could take if money had to be paid and you didn't need like an inspection or anything, you could pay that money at closing if you're the seller. But if an inspection had to be completed and the seller waited till the day of closing because they didn't want to do it, that's probably bad faith. And if I was the buyer, I would sue the seller for delaying my closing.
Mm-hmm. Okay.
Yes.
Okay. Thank you.
Yep. John, you had a question?
Thanks. Sam, is there a good amount? Recently had a scenario with an open permit. We wanted to get to closing, and what's a reasonable amount for escrow? Is there?
Well, that's a tough question, because in the NABOR contract, as you know, permits are a inspection item, and if an inspection item is not completed by closing, you escrow 200% of the estimated repair cost. But what is the 200% based on? What do you take times 200% to get the repair cost? when the permit, it might be $100 fee to get an inspection, but maybe it's a really big deal, like the pool cage is new and needs to be inspected, and if it's in the wrong place, it has to be torn down and put back in the right place. So you got $200 in escrow and a $50,000 recaging job on the property. So you, in the NABOR contract, you run into some serious issues with inspection items and the 200% rule on permits, because you can't really tell how much it's going to cost to fix the problem if it doesn't pass the inspection. So you have to be reasonable. You have to negotiate between the parties, and the contract is totally unclear. And typically we escrow a few $1,000. We get the permit closed, and then we turn the escrow back over to the seller. But it is a very complicated and difficult question under the NABOR contract, how to deal with open permits that are not clearly an amount to get them closed.
Thank you.
Yep. Other questions? Marcia, the survey is ordered by the title company. Okay, everybody, we are right at 8:31, and I like to keep these to 30 minutes. If you have any other questions, please shoot me an email or a text. Thank you all for tuning in today, and I will see you on Tuesday.